Former President Trump skipped his arraignment yesterday in Georgia, entering a not guilty plea to charges of trying to overturn the 2020 election results in Georgia. Co-defendant Rudy Giuliani today elected to do the same.
So that means that he will not appear before a Fulton County judge for next week's hearing. The judge in that Georgia case also will allow cameras in the courtroom, the first of Trump's criminal cases that will allow that to be the case. Trump and 18 other co-defendants were indicted earlier in the month.
Former President Trump faces 3 other indictments, yet remains the prohibitive Republican frontrunner in the 2024 presidential race.
But there's an effort among some Democrat groups and legal experts to use the Constitution's 14th Amendment insurrection clause to try to block him from 2024 ballots. Just this week, one such case, though, was dismissed by a Florida federal judge.
Fox 10's Lindsey Ragas spoke with a constitutional law professor to get her take on this.
The 14th Amendment bars from office anyone who once took an oath to uphold the Constitution, but then engaged in insurrection or rebellion against it.
2 conservative law professors have written a very clearly influential law review article in which they make the argument that Section 3 of the 14th Amendment clearly disqualifies Donald Trump to the extent that he gave aid and comfort to the January 6th insurrectionists.
Stephanie Lindquist is the Foundation Professor of Law and Political Science at ASU.
It addresses the question whether Section 3, that power of disqualification, is something that is what we call in law self-executing, or whether it requires Congress to pass a statute that specifically disqualifies individuals, and that it needs congressional enforcement to actually work.
Lindquist says while there may be a valid historical and legal claim that the 14th Amendment applies to Donald Trump to disqualify him from office, these questions remain.
So if indeed a state electoral official chooses to ban Donald Trump from the ballot, or if a lawsuit is brought to ban Donald Trump from a ballot somewhere in the United States, then a court will have to address the issue as to whether Donald Trump actually meets the criteria in Section 3.
Lindquist says the courts would have a hard time addressing this because they don't have the results of the federal case against Trump or the Georgia case against Trump. She adds the U.S. Supreme Court may be very reluctant about wading into this issue very close to the presidential election.
As this information goes out into the world about disqualification under Section 3 of the 14th Amendment, it may be that, this is a persuasive argument to the public that voting against Donald Trump is appropriate under the Constitution. But that, I think, is a judgment that each individual voter will make based upon his or her own conscience.